Q. How should the rules of court be construed? The rules of court should be liberally constructed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Section 6, Rule 1. What is the concept of remedial law? Distinguished between substantive and remedial law. 2006. The concept of remedial law is that it is a branch of public law which prescribes the procedural rules to be observed in litigations, whether civil, criminal, or administrative, and in special proceedings, as well as the remedies or reliefs available in each case. Substantive law is that part of the law which creates, defines, and regulates rights and obligations, the violation of which gives rise to a cause of action. On the other hand, remedial law prescribes the method of enforcing rights or obtaining redress for their invasion. Bustos versus Lucero. How are remedial laws implemented in our system of government? 2006. Remedial laws are implemented in our system of government through the judicial system, including the prosecutory service, our courts and quasi-judicial agencies. Doctrine of non-interference or doctrine of judicial stability. In rendering a decision, should a court take into consideration the possible effect of its verdict upon the political stability and economic welfare of the nation? 2003. No, because a court is required to take into consideration only the legal issues and the evidence admitted in the case. The political stability and economic welfare of the nation are extraneous to the case. They can have persuasive influence, but they are not the main factors that should be considered in deciding a case. A decision should be based on the law, rules of procedure, justice, and equity. However, in exceptional cases, the court may consider the political stability and economic welfare of the nation when these are capable of being taken into judicial notice of and are relevant to the case. Jurisdiction of courts. Supreme Court. Q. Distinguish questions of law from questions of fact. 2004. A question of law is when the doubt or difference arises as to what the law is on a certain set of facts, while a question of fact is when the doubt or difference arises as to the truth or falsehood of alleged facts. Ramos versus Pepsi-Cola Bottling of the Philippines. Q. Good Feather Corporation, through its president, Al Pacino, filed with the Regional Trial Court a complaint for specific performance against Robert White. Instead of filing an answer to the complaint, Robert White filed a motion to dismiss the complaint on the ground of lack of the appropriate board resolution from the Board of Directors of Good Feather Corporation to show the authority of Al Pacino to represent the corporation and file the complaint in its behalf. The RTC granted the motion to dismiss, and accordingly, it ordered the dismissal of the complaint. Al Pacino filed a motion for reconsideration, which the RTC denied. As nothing more could be done by Al Pacino before the RTC, he filed an appeal before the Court of Appeals. Robert White moved for dismissal of the appeal in the ground that same involved purely a question of law and should have been filed with the Supreme Court. However, Al Pacino claimed that the appeal involved mixed questions of fact and law because there must be a factual determination if, indeed, Al Pacino was duly authorized by Good Feather Corporation to file the complaint, whose position is correct. 2014. Al Pacino is correct in claiming that the appeal involved mixed questions of fact and law. There is a question of law when the doubt or difference arises as to what the law is on a certain state of facts. On the other hand, there is a question of fact when the doubt or difference arises as to the truth or falsehood of alleged facts. Mirant Philippines Corporation versus Sarillo. Since the complaint was dismissed due to the alleged lack of appropriate board resolution from the Board of Directors of Good Feather Corporation, the appeal will necessarily involve a factual determination of the authority to file the complaint for the said corporation. Hence, the appeal before the Court of Appeals is correct. Court of Appeals. Give at least 3 instances where the Court of Appeals may act as a trial court. 2008. A. In annulment of judicial under Sections 5 and 6, Rule 47, should the Court of Appeals find prima facie merit in the petition, the same shall be given due course and summons shall be served on the respondent, after which trial will follow, where the procedure in ordinary civil cases shall be observed. B. When a motion for new trial is granted by the Court of Appeals, the procedure in the new trial shall be the same as that granted by original trial court. Section 4, Rule 53. C. A petition for habeas corpus shall be set for hearing. Section 12, Rule 102. D. In a petition for the writs of amparo and habeas data, a hearing can be conducted. Letter E. Under Section 12, Rule 124 of the Rules of Criminal Procedure, the Court of Appeals has the power to try cases and conduct hearings, receive evidence, and perform any and all acts necessary to resolve factual issues, cases which fall within its original and appellate jurisdiction. Letter F. The Court of Appeals can grant a new trial based on the ground of newly discovered evidence. Section 14, Rule 124. G. The Court of Appeals under Section 6, Rule 46, whenever necessary to resolve factual issues, may conduct hearing thereon or delegate the reception of the evidence of such issues to any of its members or to an appropriate agency or office. Q. Does the Court of Appeals have jurisdiction to review the decisions in criminal and administrative cases of the Ombudsman? 2006. The Supreme Court has exclusive appellate jurisdiction over decisions of the Ombudsman in criminal cases. Section 14, RA 6770. In administrative and disciplinary cases, appeals from the Ombudsman must be taken to the Court of Appeals under Rule 43. Lanting v. Ombudsman. Court of Tax Appeals. Q. Mark filed with the Bureau of Internal Revenue a complaint for refund of taxes paid, but it was not acted upon. So he filed a similar complaint with the Court of Tax Appeals, RAFLed, to one of its divisions. Mark's complaint was dismissed. Thus, he filed with the Court of Appeals a petition for certiorari under Rule 65. Does the Court of Appeals have jurisdiction over Mark's petition? 2006. No. The procedure is governed by Section 11 of RA 9282. Decisions of a division of the Court of Tax Appeals must be appealed to the Court of Tax Appeals en banc. Further, the CTA now has the same rank as the Court of Appeals and is no longer considered as a quasi-judicial agency. It is likewise provided in the said law that the decisions of the CTA en banc are cognizable by the Supreme Court under Rule 45 of the 1997 Rules of Civil Procedure. Sandiganbayan, Q. The Ombudsman, after conducting the requisite preliminary investigation, found probable cause to charge Governor Matigas in conspiracy with Carpenter, a private individual, for violating Section 3, letter E of Republic Act 30/19, Anti-Graft and Corrupt Practices Act, as amended. Before the information could be filed with the Sandiganbayan, Governor Matigas was killed in an ambush. This notwithstanding, an information was filed against Governor Matigas and Carpintero. At the Sandiganbayan, Carpintero, through counsel, filed a motion to quash the information on the ground of lack of jurisdiction of the Sandiganbayan, arguing that with the death of Governor Matigas, there is no public officer charged in the information. Is the motion to quash legally tenable? 2014. No, the motion to quash is not legally tenable. While it is true that by reason of the death of Governor Matigas, there is no longer any public officer with whom he can be charged for violation of RA 1319. It does not mean, however, that the allegation of conspiracy between them can no longer be proved or that their alleged conspiracy is already expunged. The only thing extinguished by the death of Governor Matigas is his criminal liability. His death did not extinguish the crime, nor did it remove the basis of the charge of conspiracy between him and Carpintero. The requirement before a private person may be indicated for violation of Section 3, letter G of RA 1319, among others, is that such private person must be alleged to have acted in conspiracy with a public officer. The law, however, does not require that such person must, in all instances, be indicated together with the public officer. Indeed, it is not necessary to join all alleged co-conspirators in an indictment for conspiracy. People versus Henry T. Go. Regional Trial Courts, Q. State at least 5 civil cases that fall under the exclusive original jurisdiction of the Regional Trial Court, 2016. The Regional Trial Courts, inter alia, shall exercise exclusive original jurisdiction in the following civil cases. 1. In all civil actions in which the subject of the litigation is incapable of pecuniary estimation. 2. In all civil actions which involve title to or possession of real property or any interest therein, where the assessed value of the property involved exceeds 20,000 pesos, or for civil actions in Metro Manila where such value exceeds 50,000 pesos, except actions for forcible entry into and unlawful detainer of lands or buildings, original jurisdiction over which is conferred upon the Metropolitan Trial Courts. 3. In all actions in Admiralty and Maritime jurisdiction where the demand or claim exceeds 300,000 pesos, or in Metro Manila where such demand or claim exceeds 400,000 pesos. In all matters of probate, both testate and intestate, where the gross value of the estate exceeds 300,000 pesos, or in probate matters in Metro Manila, where such gross value exceeds 400,000 pesos. In all actions involving the contract of marriage and marital relations. 6. In all cases not within the exclusive jurisdiction of any court, tribunal, person or body exercising judicial or quasi-judicial functions. 7. In all civil actions and special proceedings falling within the exclusive jurisdiction, original, of a juvenile and domestic relations court and of the Court of Agrarian Relations as now provided by law. And 8. In all other cases in which the demand exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses and costs, or the value of the property in controversy exceeds 300,000 pesos, or in such other cases in Metro Manila where the demand exclusive of the above-mentioned item exceeds 400,000 pesos. Section 1 and 19 of Batas Pambansa 129, otherwise known as the Judiciary Reorganization Act of 1980. Q. A files an action in the Municipal Trial Court against B, the natural son of A's father, for the partition of a parcel of land located in Taytay, Rizal, with an assessed value of 20,000 pesos. B moves to dismiss the action on the ground that the case would have been brought in the RTC because the action is one that is not capable of pecuniary estimation, as it involves primarily a determination of hereditary rights and not merely the bare rights to real property. Resolves the motion. 2000. The motion should be granted. The action for partition depends on the determination of the hereditary rights of A and B, which is not capable of pecuniary estimation. Hence, even though the assessed value of the land is 20,000, the Municipal Trial Court has no jurisdiction. Russell versus Bastille, 1999. Q. A filed with the MTC of Manila an action for specific performance against B, a resident of Quezon City, to compel the latter to execute a deed of conveyance covering a parcel of land situated in Quezon City, having an assessed value of 19,000. B received the summons and a copy of the complaint of 2nd January 2003. On the 10th of 2003 January, B filed a motion to dismiss the complaint on the ground that the subject matter of the suit was incapable of pecuniary estimation. The court denied the motion. In due time, B filed with the RTC a petition for certiorari praying that the said order be set aside because the MTC has no jurisdiction over the case. On 13 February 2003, A filed with the MTC a motion to declare B in default. The motion was opposed by B on the ground that his petition for certiorari was still pending. Was the denial of the motion to dismiss the complaint correct? Answer: the denial of the motion to dismiss the complaint was not correct. Although the assessed value of the parcel of land involved was $19,000 within the jurisdiction of the MTC Manila, the action filed by A for specific performance against B to compel the latter to execute a deed of conveyance of said parcel of land was not capable of pecuniary estimation, and therefore the action was within the jurisdiction of RTC. B. Resolve the motion to declare the defendant in default. 1997, 2003, and 2012 bar. Answer: the court could declare B in default because B did not obtain a writ of preliminary injunction or a temporary restraining order from the RTC prohibiting the judge from proceeding in the case during the pendency of the petition for certiorari. Section 7, Rule 65, Diaz versus Diaz. Q. Angelina sued Armando before the Regional Trial Court of Manila to recover the ownership and possession of two parcels of land, one situated in Pampanga and the other in Bulacan, 2009. May the action prosper? Explain. Answer: no. The action may not prosper because under Republic Act 7691, exclusive original jurisdiction in civil actions which involve title to or possession or real property or any interest therein is determined on the basis of the assessed value of the land involved, whether it should be 20,000 in the rest of the Philippines outside of Manila with courts of the first level or with the regional trial court. The assessed value of the parcel of land in Pampanga is different from the assessed value of the land in Bulacan. What is involved is not merely a matter of venue, which is waivable, but a matter of jurisdiction. However, the action may prosper if jurisdiction is not an issue, because venue can be waived. Will your answer be the same if the action was for foreclosure of the mortgage over the two parcels of land? Why or why not? 2000 bar. No, the answer would not be the same. The foreclosure action should be brought in the proper court of the province where the land or any part thereof is situated, either in Pampanga or in Bulacan. Only one foreclosure action need be filed unless each parcel of land is covered by distinct mortgage contract. In foreclosure suit, the cause of action is for the violation of the terms and conditions of the mortgage contract. Hence, one foreclosure suit per mortgage contract violated is necessary. Q. On August 13, 2008, A, as shipper and consignee, loaded on the MV Atlantis in Legazpi City 100,000 pieces of century eggs. The shipment arrived in Manila, totally damaged on August 14, 2008. A filed before the Metropolitan Trial Court of Manila a complaint against B Superlines, B-Lines, owner of the MV Atlantis, for recovery of damages amounting to $167,899. He attached to the complaint the bill of lading. A. B-Lines filed a motion to dismiss upon the ground that the Regional Trial Court has exclusive original jurisdiction over all actions in admiralty and maritime claims. In his reply, A contended that while the action is indeed admiralty and maritime in nature, it is the amount of the claim, not the nature of the action, that governs jurisdiction. Pass on the motion to dismiss. Answer. The motion to dismiss is without merit and therefore should be denied. Courts of the first level have jurisdiction over civil actions where the demand is for a sum of money not exceeding 300,000 or in Metro Manila 400,000, exclusive of interest, damages, attorney's fees, litigation expenses, and costs. This jurisdiction includes admiralty and marine cases, and where the main cause of action is the claim for damages, the amount thereof shall be considered in determining the jurisdiction of the court. B. The METC denied the motion in question. A. B lines thus filed an answer raising the defense that under the bill of lading it issued to A, its liability was limited to $10,000. At the pretrial conference, B lines defined as one of the issues whether the stipulation limiting its liability to $10,000 binds A. A countered that this was no longer an issue, as B lines had failed to deny under oath the bill of lading, which of the parties is correct. Explain. The contention of B is correct. A's contention is wrong. It is A who pleaded the bill of lading as an inactional document where the stipulation limits B's liability to A to $10,000 only. The issue raised by B does not go against or impugn the genuineness and due execution of the bill of lading as an actionable document pleaded by A, but invokes the binding effect of said stipulation. The oath is not required of B because the issue raised by the latter does not impugn the genuineness and due execution of the bill of lading. Letter C. On July 21, 2009, B line served on A notice to take deposition, setting the deposition on July 29, 2009 at 8:30 a.m. at the office of its counsel in Makati. A filed to appear at the deposition taking despite notice. As counsel for B lines, how would you proceed? 2010 bar. A. As counsel for B lines, which gave notice to take the deposition, I shall proceed as follows. 1. Find out why A failed to appear at the deposition taking despite notice. 2. If failure was for valid reason, then set another date for taking the deposition. 3. If failure to appear at deposition taking was without valid reason, then I would file a motion or application in the court where the action is pending for an order to show cause for his refusal to the discovery. And 4th, for the court to issue appropriate order provided under Rule 29 of the Rules for non-compliance with a show cause order aside from contempt of court. Family courts. How should the records of child and family cases in the family courts or RTC designated by the Supreme Court to handle family court cases be treated and dealt with? Under what conditions may the identity of parties in child and family cases be divulged? 2001 bar. A. The records of child and family cases in the family courts or regional trial court designated by the Supreme Court to handle family court cases shall be dealt with utmost confidentiality. Section 12, Family Courts Act of 1997, shall not be divulged unless necessary and with authority of the judge. Q. Juliet, invoking the provisions of the Rule on Violence Against Women and Their Children filed with the RTC, designated as a family court, a petition for issuance of a temporary protection order, TPO, against her husband Romeo. The family court issued a 30-day TPO against Romeo. A day before the expiration of the TPO, Juliet filed a motion for extension. Romeo, in his opposition, raised, among others, the constitutionality of RA 9262, the Vowsy Law, arguing that the law authorizing the issuance of a TPO violates the equal protection and due process clauses of the 1987 Constitution. The family court judge, in granting the motion for extension of the TPO, declined to rule on the constitutionality of RA 9262. The family court judge reasoned that family courts are without jurisdiction to pass upon constitutional issues, being a special court of limited jurisdiction in RA 8369, the law creating the family courts does not provide for such jurisdiction. Is the family court judge correct when he declined to resolve the constitutionality of RA 9262, 2015? No, the family court judge is not correct when he declined to resolve the constitutionality of RA 9262. In Garcia v. Honorable Ray Allen Drilon, the Supreme Court held that the family courts have authority and jurisdiction to resolve the constitutionality of a statute. In spite of its designation as a family court, the RTC remains to possess the authority as a court of general original jurisdiction to pass upon all kinds of cases, whether civil, criminal, special proceedings, land registration, guardianship, naturalization, admiralty, or insolvency. This authority is embraced in the general definition of judicial power to determine the valid and binding laws in conformity with the fundamental law. Metropolitan Trial Courts, Municipal Trial Courts. Q. Filomeno brought an action in the Metropolitan Trial Court, METC, of Pasay City against Marcelino, pleading two causes of action. The first was a demand for the recovery of physical possession of a parcel of land situated in Pasay City with an assessed value of 40,000 pesos. The second was a claim for damages of 500,000 pesos for Marcelino's unlawful retention of the property. Marcelino filed a motion to dismiss on the ground that the total amount involved, which is 540,000 pesos, is beyond the jurisdiction of the METC. Is Marcelino correct? 2008. No, Marcelino is not correct. Under Republic Act No. 7691, Metropolitan Trial Court and other courts of the first level has been vested with exclusive original jurisdiction in all civil actions which involve title to or possession of real property or any interest therein, where the assessed value of the property or interest therein does not exceed 20,000 pesos, or in civil actions in Metro Manila, where such assessed value does not exceed 50,000 pesos, exclusive of interest, damages, or whatever kind, attorney's fees, litigation expenses, and costs. Pasay City, where the action for recovery of physical possession was filed, in part of Metro Manila, and therefore has exclusive jurisdiction over the parcel of land situated therein, whose assessed value is 40,000 pesos. The claim for damages of 500,000 pesos for the unlawful retention of the land involved is not determinative of the court's jurisdiction, which is based on the nature of the action. The claim for damages of 500,000 is just a consequence of the unlawful detention of the property subject of the action, which should not be taken separately from the land. Filomeno has only one cause of action, which is the action for recovery of possession of the land against Marcelino with damages. Q. Annabel filed a complaint against B for unlawful detainer before the Municipal Trial Court, MTC, of Candaba, Pampanga. After the issues had been joined, the MTC dismissed the complaint for lack of jurisdiction, after noting that the action was one for action publicana. Annabel appealed the dismissal to the RTC, which affirmed it and accordingly dismissed her appeal. She elevates the case to the Court of Appeals, which remands the case to the RTC. Is the appellate court correct? 2010. Yes, the Court of Appeal is correct in remanding the case to RTC for the latter to try the same on the merits. The RTC, having jurisdiction over the subject matter of the case appealed from MTC, should try the case on the merits as if the case was originally filed with it, and not just to affirm the dismissal of the case, RA 7691. However, vested jurisdiction over specified action publicana with courts of the first level, Metropolitan Trial Courts, Municipal Trial Courts, and Municipal Circuit Trial Courts in cases where the assessed value of the real property involved does not exceed 20,000 pesos outside Metro Manila, and in Metro Manila, where such value does not exceed 50,000 pesos. Q. Plaintiff filed a complaint for a sum of money against defendant with the METC Makati. The total amount of the demand, exclusive of interest, damages, or whatever kind, attorney's fees, litigation expenses, and costs, being 1 million. In due time, defendant filed a motion to dismiss the complaint on the ground of MTC's lack of jurisdiction over the subject matter. After due hearing, the METC ruled, number 1, that the court indeed lacked jurisdiction over the subject matter of the complaint, and 2, ordered that the case therefore should be forwarded to the proper RTC immediately. Was the court's ruling concerning jurisdiction correct? Was the court's order to forward the case correct? Explain briefly, 2000 and 2004, Bar. Yes, the METC did not have jurisdiction over the case because the total amount of the demand, exclusive of interest, damages of whatever kind, attorney's fees, litigation expenses, and costs, was 1 million. Its jurisdictional amount at this time should not exceed 400,000 pesos. Section 33 of BP 29 as amended by RA 7691. The court's order to forward the case to the RTC is not correct. It should merely dismiss the complaint. Under Section 3 of Rule 16, the court may dismiss the action or claim, deny the motion, or order the amendment of the pleading, but not to forward the case to another court. Q. Australia was the registered owner of a huge parcel of land located in a remote part of their barrio in Benguet. However, when she visited the property after she took a long vacation abroad, she was surprised to see that her childhood friend, John, had established a vacation house on her property. Both Australia and John were residents of the same barangay. To recover possession, Australia filed a complaint for ejectment with the municipal trial court, alleging that she is the true owner of the land as evidenced by her certificate of title and tax declaration, which showed the assessed value of the property as 21,000 pesos. On the other hand, John refuted Australia's claim of ownership and submitted in evidence a deed of absolute sale between him and Australia. After the filing of John's answer, the MTC observed that the real issue was one of ownership and not of possession. Hence, the MTC dismissed the complaint for lack of jurisdiction. On appeal by Australia to the Regional Trial Court, a full-blown trial was conducted as if the case was originally filed with it. The RTC reasoned that based on the assessed value of the property, it was the court of proper jurisdiction. Eventually, the RTC rendered a judgment declaring John as the owner of the land and hence entitled to the possession thereof. Was the MTC correct in dismissing the complaint for lack of jurisdiction? Why or why not? No. The Metropolitan Trial Court was not correct in dismissing the complaint for lack of jurisdiction. It is well settled that jurisdiction is determined by the allegations contained in the complaint. The contention of defendant in his motion to dismiss has nothing to do in the determination of jurisdiction. Otherwise, jurisdiction would become dependent almost entirely upon the whims of the defendant. Medical Plaza Makati Condominium versus Cullen. Relative thereto, the municipal trial courts have exclusive original jurisdiction over cases of forcible entry and unlawful detainer, Section 33, BP 129. Hence, the Metropolitan Trial Court is not correct in dismissing the complaint for lack of jurisdiction. Besides, the rules allow provisional determination of ownership in ejectment cases when the defendant raises the defense of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership. Section 16, Rule 70. Accordingly, the inferior courts have jurisdiction to resolve questions of ownership whenever it is necessary to decide the question of possession in an ejectment case. Sereno versus Spouses Gutierrez. B. Was the RTC correct in ruling that based on the assessed value of the property, the case was within its original jurisdiction and hence it may conduct a full-blown trial of the appealed case as if it was originally filed with it? Why or why not? 2014. No, it is settled that forcible entry and unlawful detainer cases are within the exclusive original jurisdiction of the MTC. Moreover, all cases decided by the MTC are generally appealable to the RTC, irrespective of the amounts involved. Special Courts. Q. What court has jurisdiction over an action for specific performance filed by a subdivision homeowner against a subdivision developer? 2002. An action for specific performance by a subdivision homeowner against a subdivision developer is within the jurisdiction of the Housing and Land Use Regulatory Board, HLURB, Section 1 of PD 1344, provides that the HLURB has jurisdiction over cases involving specific performance of contractual and statutory obligations filed by buyers of subdivision lots and condominium units against the owner, developer, dealer, broker, or salesman. Manila Bankers Life Insurance versus AD ng Cockway. How jurisdiction over the defendant is acquired. Lani filed an action for partition and accounting in the Regional Trial Court RTC of Manila against her sister Mary Rose, who is a resident of Singapore and is not found in the Philippines. Upon motion, the court ordered the publication of the summons for 3 weeks in a local tabloid, Bulgar. Linda, an OFW vacationing in the Philippines, saw the summons in Bulgar and brought a copy of the tabloid when she returned to Singapore. Linda showed the tabloid and the page containing the summons to Mary Rose, who said, "Yes, I know. My Kumari Anita scanned and emailed that page of Bulgar to me." Did the court acquire jurisdiction over Mary Rose? 2008. Answer: no. The court did not acquire jurisdiction over Mary Rose, the defendant. While serving summons by publication is allowed in this case under Section 15, Rule 14 of the Rules of Court, the required sending of the copy of the summons and the order of the court by registered mail to the last known address of the same defendant has not been followed. Service of summons by publication under said rule has not been complied with, thus there is no valid service. Totality rule. Question: lender extended to borrower a 100,000 pesos loan covered by a promissory note. Later, borrower obtained another 100,000 pesos loan, again covered by a promissory note. Still later, borrower obtained a 300,000 pesos loan secured by a real estate mortgage on his land valued at 500,000 pesos. Borrower defaulted on his payments when the loans matured. Despite demand to pay the 500,000 loan, borrower refused to pay. Lender, applying the totality rule, filed against borrower with the Regional Trial Court of Manila a collection suit for 500,000 pesos. Did lender correctly apply the totality rule and the rule on joinder of causes of action? 2015. Yes, the lender correctly applied the totality rule and the rule on joinder of causes of action because where the claims in all the causes of action are principally for recovery of sum of money, the aggregate amount of the claim shall be the test of jurisdiction. Section 5, letter D, rule number 2. Here, the total amount of the claim is 500,000. Hence, the Regional Trial Court of Manila has jurisdiction over the suit. At any rate, it is immaterial that one of the loans is secured by a real estate mortgage because the lender opted to file a collection of sum of money instead of foreclosure of the said mortgage. Q. At the trial, borrower's lawyers, while cross-examining lender, successfully elicited an admission from the latter that the 2 promissory notes have been paid. Thereafter, borrower's lawyer filed a motion to dismiss the case on the ground that, as proven, only 300,000 was the amount due to lender, and which claim is within the exclusive original jurisdiction of MTC. He further argued that lack of jurisdiction over the subject matter can be raised at any stage of the proceedings. Should the court dismiss the case? 2015. No, the court should not dismiss the case. What determines the jurisdiction of the court is the nature of the action pleaded as appearing from the allegations in the complaint. The averments therein and the character of the relief sought are the ones to be consulted. Navida versus Honorable Teodoro A. Dizon. Accordingly, even if the defendant is able to prove in the course of the trial that a lesser amount is due, the court does not lose jurisdiction and a dismissal of the case is not in order. Paadlan versus Tinglasan. Civil procedure. Personal actions and real actions. Q. What do you mean by a real action? B. Personal action, 2006. Real actions are actions affecting title to or possession of real property or an interest therein. All other actions are personal actions. Q. Eduardo, a resident of the city of Manila, filed before the Regional Trial Court of Manila a complaint for the annulment of a deed of real estate mortgage he signed in favor of Galaxy, and the consequent foreclosure and auction sale on his mortgage Makati property. Galaxy filed a motion to dismiss on the ground of improper venue, alleging that the complaint should be filed with the RTC of Makati since the complaint involves the ownership and possession of Eduardo's lot, resolve the motion with reasons 2016. A. The motion to dismiss should be granted. An action for nullification of the mortgage documents and foreclosure of the mortgage property is a real action that affects the title to the property. Thus, venue of the real action is before the court having jurisdiction over the territory in which the property lies. Jimmy T. Go versus United Coconut Planners Bank. 156187. In Fortune Motors versus Court of Appeals, the Supreme Court also held that an action to annul a foreclosure sale of a real estate mortgage is no different from an action to annul a private sale of real property. While it is true that petitioner does not directly seek the recovery of title or possession of the property in question, his action for annulment of sale and his claim for damages are closely intertwined with the issue of ownership of the building, which under the law is considered immovable property, the recovery of which is petitioner's primary objective. The prevalent doctrine is that an action for the annulment or rescission of a sale of real property does not operate to efface the fundamental and prime objective and nature of the case, which is to recover said real property. It is a real action. Paglaum Management and Development Corporation versus Union Bank of the Philippines. Being a real action, it shall be commenced and tried in the proper court which has jurisdiction over the area where the real property involved, or a portion thereof, is situated. Section 1, Rule 4, Rules of Court. The complaint should be filed in the RTC of Makati, where the mortgage property is situated. Alternative answer. The motion to dismiss should be denied. An action for the annulment of a real estate mortgage is a personal action, which may be commenced and tried where the defendant or any of the defendants resides or may be found, or where the plaintiff or any of the plaintiffs reside or may be found, at the election of plaintiff. Section 2, Rule 4, Rules of Court. Chua versus Total Office Products and Services, September 30, 2005. Cause of action. Distinguish cause of action from action. 1997-1999. A. An action is one by which a party sues another for the enforcement or protection of a right, or the prevention or redress of a wrong. Section 3, letter A, second paragraph. A cause of action is the act or omission by which a party violates the right of another. Section 2, Rule 2. An action must be based on a cause of action. Section 1, Rule 2. Q. A bought a Volvo sedan from ABC Cars for $5 million. ABC Cars, before delivering to A, had the car rust-proofed and tinted by XYZ Detailing. When delivered to A, the car's upholstery was found to be damaged. ABC Cars and XYZ Detailing both deny any liability. Who can A sue and on what costs or causes of action? Explain, 2012. A can file an action for specific performance and damages against ABC Cars since the damage to the Volvo sedan upholstery was caused before delivery of the same to A, and therefore prior to the transfer of ownership to the latter. Article 1477 NCC. Under Article 1170 of the Civil Code, those who contravene the tenor of the obligation are liable for damages. Hence, an action for specific performance against ABC Corporation to deliver the agreed Volvo sedan in the contract, free form, and damage or defects with corresponding damages will lie against ABC Cars. Splitting a single cause of action and its effect. Q. What is the rule against splitting a cause of action and its effect on the respective rights of the parties for failure to comply with the same? 1999. The rule against splitting a cause of action and its effect are that if two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment upon the merits in one is available as a ground for the dismissal of the others. Q. A purchased a lot from B for $1.5 million. He gave a down payment of $500,000, signed a promissory note payable in 30 days after date, and a security for the settlement of the obligation, mortgaged the same lot to B. When the note fell due and A failed to pay, B commenced suit to recover from A the balance of $1 million. After securing a favorable judgment on his claim, B brought another action against A before the same court to foreclose the mortgage. A now files a motion to dismiss the second action on the ground of bar by prior judgment. Rule on the motion. A. The motion to dismiss should be granted. When B commenced suit to collect on the promissory note, he waived his right to foreclose the mortgage. B split his cause of action. Q. Rafael, a warehouse man, filed a complaint against B Corporation, X Corporation, and Y Corporation to compel them to interplead. He alleged therein that the three corporations claimed title and right of possession over the goods deposited in his warehouse, and that he was uncertain which of them was entitled to the goods. After due proceedings, judgment was rendered by the court declaring that X Corporation was entitled to the goods. The decision became final and executory. Rafael filed a complaint against X Corporation for the payment of $100,000 for storage charges and other advances for the goods. X Corporation filed a motion to dismiss the complaint on the ground of res judicata. X Corporation alleged that Rafael should have incorporated in his complaint for interpleader his claim for storage fees and advances, that for his failure he was barred from interposing his claim. Rafael replied that he could not have claimed storage fees and other advances in his complaint for interpleader because he was not yet certain as to who was liable thereof. Resolved the motion, 2005. The motion to dismiss should be granted. Rafael should have incorporated in his complaint for interpleader his claim for storage fees and advances, the amounts of which were obviously determinable at the time of the filing of the complaint. They are part of Rafael's cause of action, which he may not split. Hence, when the warehouseman asked the court to ascertain who among the defendants are entitled to the goods, he also has the right to ask who should pay for the storage fees and other related expenses. The filing of the interpleader is available as a ground for dismissal for the second case, Section 4, Rule 2. It is akin to a compulsory counterclaim, which, if not set up, shall be barred, Section 2, Rule 9. Arreza v. Diaz, 2001. Q. Rolando filed a petition for a declaration of the nullity of his marriage to Carmela because of alleged psychological incapacity of the latter. After trial, the court rendered judgment dismissing the petition on the ground that Rolando failed to prove the psychological incapacity of his wife. The judgment having become final, Rolando filed another petition, this time on the ground that his marriage to Carmela had been celebrated without a license. Is the second action barred by the judgment on the first? 2002. No, the second action is not barred by the judgment in the first because they are different causes of action. The first is for annulment of marriage on the ground of psychological incapacity under Article 36 of the Family Code, while the second is for the declaration of nullity of the marriage in view of the absence of a basic requirement, which is a marriage license, Article 9 and 35, Number 3, Family Code. They are different causes of action because the evidence required to prove them are not the same. Pagsisihan v. Court of Appeals. Joinder and misjoinder of causes of action. Q. P sued A and B in one complaint in the RTC Manila. The cause of action against A being an overdue promissory note for 300,000 pesos, and that against B being on an alleged balance of 300,000 pesos on the purchase price of goods sold on credit. Does the RTC Manila have jurisdiction over the case? 2002. No, the RTC Manila has no jurisdiction over the case. A and B could not be joined as defendants in one complaint because the right to relief against both defendants do not arise out of the same transaction or series of transactions, and there is no common question of fact common to both. Rule 3, Section 6, hence separate complaints will have to be filed and they would fall under the jurisdiction of the Metropolitan Trial Court. Flores v. Mallory Phillips. Q. Give the effects of the following. 1. Splitting a single cause of action, and 2. Non-joinder of a necessary party, 1998. Answer to number 1. The effect of splitting a single cause of action is found in the rules as follows. If two or more suits are instituted on the basis of the same cause of action, the filing of one or a judgment on the merits in any one is available as a ground for the dismissal of the others. Section 4, Rule 2. Number 2. The effect of the non-joinder of a necessary party may be stated as follows. The court may order the inclusion of an omitted necessary party if jurisdiction over his person may be obtained. The failure to comply with the order for his inclusion without justifiable cause is a waiver of the claim against such party. The court may proceed with the action, but the judgment rendered shall be without prejudice to the rights of such necessary party. Section 9, Rule 3. Q. What is the rule on joinder of causes of action? 1999 bar. A. The rule on joinder of causes of action is that a party may in one pleading assert in the alternative or otherwise as many causes of action as he may have against an opposing party, provided that the rule on joinder or parties is complied with. The joinder shall not include special civil actions or actions governed by special rules, but may include causes of action pertaining to different venues or jurisdictions, provided one cause of action falls within the jurisdiction of a regional trial court and venue lies therein, and the aggregate amount claimed shall be the test of jurisdiction where the claim in all the causes of action are principally for the recovery of money. Section 5, Rule 2. Q. A secured two loans from B, one for 500,000 and the other for 1 million, payable on different dates. Both have fallen due. Is B obliged to file only one complaint against A for the recovery of both loans? 1999. No. Joinder is only permissive since the loans are separate loans, which may be governed by the different terms and conditions. The two loans give rise to two separate causes of action and may be the basis of two separate complaints. Q. Perry is a resident of Manila, while Ricky and Marvin are residents of Batangas City. They are the co-owners of a parcel of residential land located in Pasay City with an assessed value of 100,000 pesos. Perry borrowed 100,000 from Ricky, which promised to pay on or before December 1, 2004. However, Perry failed to pay his loan. Perry also rejected Ricky and Marvin's proposal to partition the property. Ricky filed a complaint against Perry and Marvin in the RTC of Pasay City for the partition of the property. He also incorporated in his complaint his action against Perry for the collection of the latter's 100,000 loan, plus interest and attorney's fees. State with reason whether it was proper for Ricky to join his causes of action in his complaint for partition against Perry and Marvin in the RTC of Pasay. 2005. A. It was not proper for Ricky to join his causes of action against Perry in his complaint for partition against Perry and Marvin. The causes of action may be between the same parties, Ricky and Perry, with respect to the loan but not with respect to the partition, which includes Marvin. The joinder is between a partition and a sum of money, but partition is a special civil action under Rule 69, which cannot be joined with other causes of action. Section 5, Letter B, Rule 2. Also, the causes of action pertain to different venues and jurisdictions. The case of a sum of money pertains to the municipal court and cannot be filed in Pasay City because the plaintiff is from Manila, while Ricky and Marvin are from Batangas City. Section 5, Rule 2. Parties to civil actions, real parties in interest, indispensable parties, representatives as parties, necessary parties, indigent parties, alternative defendants. Q. In 1996, Congress passed R.A. 8189, otherwise known as the Voters Registration Act of 1996, providing for the computerization of elections. Pursuant thereto, the COMELEC approved the Voters Registration and Identification System (VIRUS) project. It issued invitations to pre-qualify and bid for the project. After the public bidding, Futukina was declared the winning bidder with a bid of 6 billion and was issued a notice of award. But COMELEC Chairman Jenner Go objected to the award on the ground that under the Appropriations Act, the budget for the COMELEC's modernization is only 1 billion. He announced to the public that the VIRUS project has been set aside. Two commissioners sided with Chairman Go, but the majority voted to uphold the contract. Meanwhile, Futukina filed with RTC a petition for mandamus to compel the COMELEC to implement the contract. The Office of the Solicitor General OSG, representing Chairman Go, opposed the petition on the ground that mandamus does not lie to enforce contractual obligations. During the proceedings, the majority commissioners filed a manifestation that Chairman Go was not authorized by the COMELEC and Bank to oppose the petition. May the OSG represent Chairman Go before the RTC, notwithstanding that his position is contrary to that of the majority, 2002. Yes, the OSG may represent the COMELEC chairman before the RTC, notwithstanding that his position is contrary to that of the majority of the commission members in the COMELEC, because the OSG is an independent office. Its hands are not shackled to the cause of its client agency. The primordial concern of the OSG is to see to it that the best interest of the government is upheld. COMELEC versus Keanu Padilla. Q. Half-brothers Roscoe and Salvio inherited from their father a vast tract of unregistered land. Roscoe succeeded in gaining possession of the parcel of land in its entirety and transferring the tax declaration thereon in his name. Roscoe sold the northern half to Bono, Salvio's cousin. Upon learning of the sale, Salvio asked Roscoe to convey the southern half to him. Roscoe refused, as he even sold 1/3 of the southern half along the west to Carlo. Thereupon, Salvio filed an action for the reconveyance of the southern half against Roscoe only. Carlo was not impleaded. After filing his answer, Roscoe sold the middle third of the southern half to Nina. Salvio did not amend the complaint to implead Nina. After trial, the court rendered judgment ordering Roscoe to reconvey the entire southern half to Salvio. The judgment became final and executory. A writ of execution having been issued, the sheriff required Roscoe, Carlo, and Nina to vacate the southern half and yield possession thereof to Salvio as the prevailing party. Carlo and Nina refused, contending that they are not bound by the judgment as they are not parties to the case. Is the contention tenable? 2008. Answer: yes. In case of transfer of interest pending litigation, the action may be continued by or against the original party unless the court, upon motion, directs a person to be substituted in the action or joined with the original party. Section 19, Rule 3. The owners of property over which reconveyance is asserted are indispensable parties and must be joined in the action. Accordingly, the contention of Carlo, who is such party to the action filed by Salvio, is tenable. He is not bound by the judgment because he became a co-owner of the land before the case was filed, and yet he has not been included as a party thereto. Matugina, Integrated Wood Products versus Court of Appeals. Nina, however, is a successor in interest of Roscoe and privy to the case. Hence, she is bound by the judgment as against Roscoe, although she is not party to the case. Section 19, Rule 3. Cabresos versus Tero. A judgment is conclusive between the parties and their successors in interest by title subsequent to the case. Section 47, Rule 39. Q. Strauss filed a complaint against Wagner for cancellation of title. Wagner moved to dismiss the complaint because Craig, to whom he mortgaged the property as duly annotated in the TCT, was not impleaded as defendant. Should the complaint be dismissed? Answer: no. The complaint should not be dismissed because the mere non-joinder of an indispensable party is not a ground for the dismissal of the action. Section 11, Rule 3, Republic versus Honorable Mangotara, 2010. B. If the case should proceed to trial without Greg being impleaded as a party to the case, what is his remedy to protect his interest? 2015. If the case should proceed to trial without Greg being impleaded as a party, he may intervene in the action. Section 1, Rule 19. He may also file a petition for annulment of judgment under Rule 47 of the Rules of Court. In Metrobank versus Honorable Floro Alejo, September 10, 2001, the Supreme Court held that in a suit to nullify an existing torn certificate of title TCT in which a real estate mortgage is annotated, the mortgagee is an indispensable party. In such suit, a decision canceling the TCT and the mortgage annotation is subject to a petition for annulment of judgment because the non-joinder of a mortgagee deprived the court of jurisdiction to pass upon the controversy. Class suit. Q. Distinguish a derivative suit from a class suit 2005. A. A derivative suit is a suit in equity that is filed by a minority shareholder in behalf of a corporation to redress wrongs committed against it, for which the directors refuse to sue, the real party in interest being the corporation itself, Lim versus Lim U. A class suit is filed in behalf of many persons, so numerous that it is impracticable to join all as parties. Section 12, Rule 3. Effect of death of party litigant. What is the effect of the death of a party upon a pending action? 1999. When the claim in a pending action is purely personal, the death of either of the parties extinguishes the claim and the action is dismissed. When the claim is not purely personal and is not thereby extinguished, the party should be substituted by his heirs or his executor or administrator. Section 16, Rule 3. If the action is for recovery of money arising from contract, express or implied, and the defendant dies before entry of final judgment in the court in which the action was pending at the time of such death, it shall not be dismissed but shall instead be allowed to continue until entry of final judgment. A favorable judgment obtained by the plaintiff shall be enforced in the manner provided in the rules for prosecuting claims against the estate of a deceased person. Section 20, Rule 3.